Hi everybody, thanks for joining us. My name's Hannah Clifford. I'm a Senior Associate in the Employment team at Irwin Mitchell. You're also joined today by Laura, my colleague, who's going to be looking at the questions that you send in. As I'm going through this, please do send questions in through the Q&A function. And what we'll do is we'll collate those, and then at the end of the webinar we'll go through those and answer those for you. I'm also joined by my colleague James from a technical point of view, so if you've got any technical issues, please just let him know. Just moving on to the next slide, this sets out the agenda of what it is that we're going to touch on today. So there's a fair amount to get through. I'm going to aim to be finished in about 45 minutes or so to have time to take questions, and please, as I say, do ask questions and send them through on the Q&A function. Firstly, I just wanted to, in relation to all of that there, just take a step back and look at what's happening in terms of employment law. So there's loads of changes going on at the moment, but it's all against the backdrop of our existing laws. So where changes have been brought in, those have been largely by way of guidance rather than changes in the laws as such. It means that the guidance can be updated far quicker, which is obviously a great thing when things are moving so quickly, but it does also mean that it can be hard for employers to keep up and demonstrate compliance. And the furlough scheme is a prime example. The other thing that it means is that there's lots of changes. So just bear in mind that, because I know that this is being recorded, this is only correct as at today, which is the morning of the 15th of May, because we're likely to get further updates even today and over the weekend. So just moving on to the next slide, I just wanted to first of all touch on where we are at the moment with the latest position in terms of furlough. So as you'll probably be aware, the Chancellor gave an update on Tuesday to say that the coronavirus job retention scheme has been extended for a further 4 months until the end of October. So the scheme is going to continue as it is at the moment until the end of July, so the 31st of July. And then from the 1st of August until the end of October, the changes will be made, and the government said to make that more flexible. What we know that means at the moment is two things. So firstly, employees will be able to return on a part-time basis and still be paid some furlough. That's something that unions and employers have been asking for a while. The second thing, so the not so good news, is that employers will also have to, from that date, make a contribution towards the furlough. So as you know, at the moment, furlough pay only has to be paid at 80%, and the government will fund that. Employers can choose to top that up. It looks like from the 1st of August, that won't be a choice. Employers are going to have to top it up. We don't yet know what that looks like. We're waiting for further details, which should be given it by the end of May. That's the deadline that will be given. But it looks likely, or the discussions have been around the fact that furlough, the government's contribution to furlough will be reduced to 60%, and perhaps employers will have to top that up by 20% to reach the 80%. We do know that it will remain at 80% all in, with the employer's contribution as well. There was also some debate about whether the furlough scheme will be withdrawn from those sectors that are continuing to operate. But the Chancellor's made it really clear, albeit only by his official Twitter feed, that the scheme will continue for all sectors in all regions of the UK. We don't know whether other changes are going to be made. So, for example, lots of businesses have asked for the minimum furlough period of 3 weeks to be reduced to make it a bit easier to rotate furlough. That might be answered when we get further information through. So just moving on to the next slide, just to touch on the basic principles of furlough, which you may well be aware of, having furloughed people, because currently around 7.5 million people in the UK have been furloughed. I've set out some of the basics there. Employees have to agree to be furloughed, and as I mentioned before, it has to be for a minimum of 3 weeks. Employees can't work for their employer during that, although they can carry out some training, but that has to be paid at national minimum wage rates. The scheme pays up to 80% of wages, up to a maximum of £2,500 per month, and it's available to a whole range of workers, so including those that work part-time, casual and 0 hours. Employers can now furlough staff who've been on their payroll on or before the 19th of March, as long as they notified HMRC via a real-time information submission on or by that date. So before that, the government had said that all employees had to be on the payroll by the 28th of February, so that excluded loads of new starters from the scheme and caused a bit of an uproar, so it's good that they've done that. Also, employees that have transferred under a TUPE scheme after the 28th of February can also now be furloughed. They've confirmed that the reclaimable national insurance and pension elements are on the furlough salary, not on the normal salary. Employers cannot work for organisations that are linked to the employer. So I mentioned before that they can't work for the employer. And the government's also confirmed that people returning from family related leave, such as, for example, maternity leave, should have their furloughed salary calculated against their pre-furlough salary rather than that lower furlough salary. So just moving on to the next slide and to touch on some of the issues for employers. So in relation to pay, we have now actually had some really helpful guidance from the government. So that includes some worked examples and a calculator, which is going to work for most employees. I won't go through the ins and outs of calculating what you can get back, because the calculator will help you with that. But what we do know is that in calculating the furlough pay, and 80% of the furlough pay, you should be taking into account the regular payments the employer is obliged to make, including regular wages you make to the employees, so non-discretionary overtime, fees, commission payments and piece rate payments. So you can't include the following. You can't include payments, any payments basically that are made at the employer's discretion. So that's discretionary commission, discretionary bonuses, tips, etc. Non-cash benefits, non-monetary benefits, so benefits in kind, like a company car, and salary sacrifice schemes that reduce their taxable pay. I've mentioned at the bottom there that there are some inconsistencies. As I said before, the goalposts have been moved times, and there are what I'm talking about here, just to be clear, is the government's guidance to employees, which they're publishing on their website. But what they've also done is they've provided a direction to HMRC. I don't know whether anyone's tried to read through it. It's really hard to follow. But that's what HMRC will be acting on when they look at these payments. And the difficulty is that there's inconsistencies between what the government's advising employers and what the direction says to HMRC. So as a matter of law, if there are inconsistencies, the direction will prevail. But HMRC has said, but again, unfortunately, this is only by Twitter at the moment, that it only expects employers to follow the government guidance. So whilst that will be indicative of how HMRC will approach the claims in practice, it doesn't have any bearing legally. I think all we can do is act on the guidance we're given, and I would really hope that HMRC won't make a big deal about, or they shouldn't, do anything that is to the detriment of employers that have followed guidance in good faith. So we'll just have to see how that plays out. But I think the best thing to do would be to follow the guidance that's given to you. So moving on to the next slide, in terms of HMRC's portal declaration. That declaration that you have to sign once you, or tick the box off, once you put your claim in, is key. So what that says, as you'll see there, is that you have to declare that the costs of employing the furloughed employee arise from coronavirus, essentially. It's a really wide scope, and we didn't think that would be the case at first. At first, we thought that the declaration, that what employers would have to say is that employees would have been made redundant if it were not for the furlough leave, but it's wider than that. So you don't have to have an employee that's at risk of redundancy for it. You just bear in mind you need to keep records of the agreement to furlough for 5 years. There is, just to make you aware of another couple of points, there is a phone line to report employers who are abusing the scheme. All of the amount, as you'll probably be aware, that you get through the furlough scheme has to be paid in money and not in benefits. Just moving on to the next slide, so furlough and the grey areas. There are still some areas of confusion, even though some guidance has been provided. So one of these is about whether there needs to be an agreement to furlough. So the government requires the direction that I was talking about that the government's provided to HMRC requires there to be a written agreement. but the guidance just refers to a written record, and it expressly states that the employee doesn't have to provide a written response. The best practice is to get some signed consent to this variation. Another point that's a bit of a grey area is sick leave, because the guidance to employers says that you can basically choose, if someone's on sick leave, whether you furlough them. But the direction that's been given to the HMRC states that in fact people can only be furloughed once they've exhausted their SSP. So it's a bit of a contradiction there. The other point that there's a bit of a contradiction about is staff that are shielding, because they are now, if they're shielding due to medical advice, they're now entitled to SSP. And the guidance to employers again says, well, you can choose to furlough those people if you want. The direction to HMRC says that they can only be furloughed once they have exhausted their right to SSP. Obviously, it's better for them if they can be furloughed, because sick pay is only paid at just under £96 a week. So still some grey areas. They might be resolved in further guidance. Just moving on to the next slide, furlough exit plans, which is a key point that we're now all thinking about. I've set out some options there. And the reason that I've said you might want to wait until the end of May to decide is because that should be the point at which we know what the government is going to put in place from August to October in terms of what contributions it expects employers to make. So I know that we're all working towards hair salons and beauty salons being open from the 4th of July, and hopefully that should also be clearer as we get towards the end of the month. One thing that I would think carefully about at the moment is if you top up furlough payments to 100%, whether the business can sustain that until the end of October, especially given that that additional contribution will need to be made from August. So in an ideal world, you'll be able to return to business as normal, but what if that isn't possible? Well, what you'll need to do is look at all of the options and the economic impact on the business. As set out on the slide, there are ways of reducing payroll costs without making redundancies. So taking actions such as reducing hours and pay, that will most likely require you to make a change to the employee's contract, and I'm going to touch on that separately shortly. But in any event, if you're going to be affecting a fair redundancy process, if those options aren't enough and you do need to make redundancies, you do need to have applied your mind to ways in which those redundancies can be reduced or avoided. So you will need to at least think about those options. Moving on to the next slide, getting people back to work. Now, as you'll be aware, Boris Johnson stated open and they can't work from home. Actually, most of the clients that I've been advising already have employees continuing to go into the workplace, and the announcement on Sunday made little difference because they've already carried out a risk assessment and put actions in or put steps in place at the workplace to try and make it as safe as possible. The interesting point about that statement by Boris Johnson is that there is an implied duty in every contract of employment that employers will protect the health and safety of its employees. So regardless of the government's stance or the government's statement, if an employer doesn't consider that it can make the workplace safe for the employees, it shouldn't be telling employees to physically return to it. The government has produced some guidance that's actually really helpful in terms of steps that you'll need to follow, depending on the type of workplace. As you'll see, there's 8 documents. I think for you, the most relevant guidance, if you haven't already read through it, would be to have a look at factory plants, warehouses, offices and shops. So there's some detailed guidance set out there. Just bear in mind that this applies to England only, by the way, as I've noted at the bottom there. Just wanted to go on to the next slide to touch on risk assessments, which is within those guidance documents. But we expect the government to require most organisations to produce a written risk assessment identifying the risks to its staff if they return during the pandemic, and to keep that under review. So under existing legislation, employers have to identify what might cause an injury or illness and decide how likely it is that someone could be harmed, so what the risk is, and take action to eliminate that. Now, clearly, COVID-19 is a hazard and it poses a significant risk of harm and death to some people, particularly those considered to be high risk. So employers just need to do what is reasonably practicable to control the risk. Now, that might involve different approaches being applied to different groups, but might include, well, certainly following the government guidance, social distancing, providing suitable hand washing facilities, additional cleaning, introducing one-way flow systems, for example, through buildings, maintaining stable groups of employees in different areas, and providing suitable PPE. You'll also need to give some thought as to how staff are travelling to work, particularly if they rely on public transport, and of course any government guidance issued in relation to that should be followed. Now, those measures about risk assessments, etc., might require collective consultation with safety representatives if there's a recognised trade union, so just bear that in mind. Moving on to the next slide, I wanted to look at some different groups of people separately. So first of all, I want to look at staff that are shielding or vulnerable. So just to be clear, staff that are shielding are those that got the letter from the NHS saying that they must stay at home, but just bear in mind that it appears that some letters have been missed, so it might be that employees have to shield and they don't actually have that letter. Anyone that's shielding in line with medical advice must remain at home, and just bear in mind that that group is likely to be disabled within the meaning of the Equality Act and are entitled to reasonable adjustments being made. So most people considered to be the most vulnerable, as I say, they might have got letters. You can ask for a copy of that letter, but I wouldn't say that you need to have a copy of that letter in order to be thinking about making reasonable adjustments for them. They're the group that we need to take most care of. Vulnerable people, there's a government list of people that are at high risk. So it doesn't yet include BAME groups who are also thought to be at high risk, but most people in that kind of high risk group will probably be disabled within the meaning of discrimination laws as well, except for those that are pregnant who are separately covered, and those who were over 70 years old. But you do need to take particular care over all of those people that are in the vulnerable category. You probably already know if your staff fall within that category, but if you don't, then you'll need to, I'd suggest as a first case, talking to them, and you might want to get some advice from occupational health or a doctor. One point that I just wanted to make, which is at the bottom there, is that there is protection in the law. More generally, this hasn't just come about because of the pandemic. There's protection in the law where employees who think that they are in circumstances of serious and imminent danger refuse to work, say that they're not going to come to work, leave work, or take some other step to protect themselves from danger. Now, without a doubt, exposure to COVID-19 poses a serious and imminent risk in most workplaces. You might disagree with the employee's assessment of that risk. So you might think, well, I've done absolutely everything I can to make it safe, and your fears are unfounded. That doesn't matter in terms of that claim that they can make in employment law. So an employee can still make a claim in employment law if, for example, you give them a written warning or dismiss them for not coming in, even if your workplace is completely safe, if they have a true and an honestly held belief that they're going to be in danger. So I think that this is going to be a really tricky area. And the best that you can do, I think, is communicate with your staff, try and find out what their particular issues is, talk about the measures you're taking and try and reassure them and make changes as much as you can. Just moving on to the next slide, I've put here some options for those staff that are shielding or vulnerable. So what if they can't carry out their duties from home? Shielding, as I've said, you'd basically be looking at SSP or furloughing. And for your vulnerable staff, still need to, as I say, take clear steps to protect them. Look at whether you can adjust working conditions or provide PPE if you can't socially distance. You can potentially treat that as them being off sick, or furlough them, allow them unpaid leave. There are, in terms of furloughing, there are restrictions, just bear in mind, on public sector employees, and there is also that issue that I spoke about earlier, where there is a contradiction at the moment whether you can furlough someone without them having run out their entitlement to SSP. Moving on to the next slide, on pregnant women, they are included in the list of vulnerable people, and they've been told to take particular care to minimise their contact with others and to socially distant. It looks at the moment as though pregnant women who are in their third trimester are particularly at risk. It's worth bearing in mind that they have a number of rights due to their pregnancy, irrespective of the current pandemic. And as has always been the case, once a member of staff has told you that they're pregnant, you need to carry out a specific risk assessment and take steps to protect that woman from all of the steps that you've identified. So at the moment, that risk assessment would obviously include catching the virus. I've set out some suggestions there for what you might do with your pregnant employees, but you will need to think about what you can do. If suitable, as I've said in the third bullet point, it might get to the point where you need to suspend her on full pay. You can't unfortunately ask a woman to start maternity leave earlier unless she is absent from work with a pregnancy related illness. Just bear in mind that employers are expected to reduce risk to its lowest acceptable limit. So moving on to slide 14. So what if the employee isn't in one of those protected categories, but they are just afraid to return to work? Well, if they are afraid to return, I think you'd need to ask what the reason for that is. If they are afraid to return to work because they are living with someone that's shielding, well, technically the government advice at the moment is that anyone living with someone that's shielding doesn't have to shield themselves. So instead, they're asked to minimise the time they spend together in shared spaces, sleep in a different room. So if someone's living with someone that's shielding, you might want to ask them what their living arrangements are like, because if they live in a one-bed flat with them, it's obviously going to be more difficult for them to distance themselves. You can ask to see a copy of the shielding letter for the person that they live with, but just bear in mind they don't have to provide it to you, and it's obviously subject to data protection issues. Now, for those employees, you can, at first line, always think about whether they can work from home. Ideally, people should be working from home. Provide some PPE. So if it's not possible for them to work from home, then think about how you can make the workplace as safe as possible. So think about providing PPE, adjusting their work to avoid contact with others if you can't keep them socially distanced. Think about whether you can furlough them, obviously subject to the restrictions that we've already spoken about, or allow them to take unpaid leave. For the reasons that I outlined before, I would be really reticent at the moment to be disciplining or dismissing anybody that has expressed that they don't want to return to work. What if there are no underlying medical conditions and they're not living with anyone, but they're still just generally worried about returning to work? I'd suggest that you take those concerns seriously and try to alleviate them by discussing what you've already put in place, the risk assessments that you've carried out, and the steps that you have put in place to minimise the risk. If you can't persuade them to return, then of course the first line is to let them work from home if they can. Otherwise, I would suggest to them that you would be willing for them to take unpaid leave, and that will really help to flush out the kind of people that aren't really afraid to return to work but just kind of would rather not. Bear in mind that any employee with depression or other mental health issues might feel particularly anxious. So if they've got a disability, again, we need to consider reasonable adjustments. So you'll need to think about what in particular can be done with them. Moving on to the next slide, what about staff with caring responsibilities? Obviously, well, if they are caring for someone that's shielding, my advice that I've just gone through would apply. If they are caring for children, then they might not just be able to physically return if schools and nurseries are still closed. Again, first line is to think about whether they can continue to work from home or work from home at all if they're not doing so already. If not, then employees with children are potentially entitled to some unpaid dependence leave. or up to 4 weeks parental leave, and you can put that in place without the usual notice requirements. Again, that's unpaid. So there are various options to look at. But I think the most important point with all of those categories of people is to listen really carefully to what they're saying, what the issues are, and try to resolve it. I would strongly recommend that you keep evidence of what you've thought about and what's been put in place, just in case you need it for any particular claim or reason in the future. Moving on to the next slide, I wanted to talk about changing terms and conditions, because it might be, as I mentioned earlier, that rather than making redundancies, you think that it might be enough if you reduce hours or pay, for example. The easiest way to do that is in line with the contract itself. So some contracts contain what's known as a flexibility clause, and it will be a clause that allows you to make certain changes, but that has to be fair and specific and narrow in scope. So for example, if you have a clause in your contract that says we can change the pay date to within a week of what it is at the moment, you can probably rely on that to change the pay date. If you've got a clause in there that says we can make any changes anytime we want, that's not going to be enforceable. It's unlikely, very, very unlikely, if you want to reduce pay or reduce hours, that there'll be a clause in your contract expressly allowing you to do that, unless someone's, for example, on a 0 hours contract where you can tell them the hours that they're working in advance, and those vary from week to week. So if you can't change terms in line with the contract, if we just move on to the next slide, what if there's no contractual right to vary? Well, the next best way is to seek agreement to those changes. So depending on the situation and the financial state of the company, employees may well agree to cut their hours, cut their pay in order to reduce redundancies. If they agree, you need to get their agreement in writing, and it needs to be signed. If they don't agree, if you can't get their agreement legally, and this applies not just during the pandemic, but to any contractual changes, if they don't agree, you've got two options. So firstly, you can always impose the changes. So you just impose changes and then rely on the fact, if they keep working for you, say, well, you've implied your consent to that. That's really risky for a number of reasons. For example, if you reduce pay and you just impose those changes, an employee can carry on quite happily working for you, but they can then make a claim while they're still employed by you for unlawful deduction from wages. And it's likely that if you haven't got their signed agreement, you'll need to pay those back to them anyway. The second option, which is probably the better option if you're looking to reduce hours or pay, is to consult with the employees about why you want to change the terms, and look and try and get their agreement. If they don't agree, then put them on notice that you're going to dismiss them and offer them re-engagement on the new terms. That puts a bit of pressure on them, because what the claim that they'd be looking at is not one of unlawful deduction from wages, but unfair dismissal. And what an employee has to do in a claim for unfair dismissal is to mitigate their losses by getting another job. So you would say, well, this is a reasonable job for you to take. Looking at that, obviously the risk is a claim of unfair dismissal. If they make a claim for that, the kind of things that a tribunal will look at is what your business case is for making the changes, the employee's reasons for refusing, how many employees agreed, whether you were flexible and your views were genuinely taken into account, and the consultation that was carried out. Moving on to the next slide, if you don't think that changes will be sufficient and you just need to cut costs by reducing staff, you need to bear in mind that employees with over 103 weeks service will be entitled to bring a claim of unfair dismissal. So you often hear 2 years bandied around. Bear in mind it's just 2 years less a week, because you add on the statutory notice period. So in order to avoid any claim of unfair dismissal, you need a fair reason and you need to follow a fair process. So redundancy is a potentially fair reason to dismiss an employee. If you've got a reduced requirement for employees to carry out work of a particular kind, then you probably can show that there is a redundancy situation. But you'll see that the fair process there that I've set out includes warning and consultation. Now, the consultation needs to be on ways of avoiding or minimising redundancies. The interesting thing at the moment is that obviously we've got the furlough scheme in place. So I think an employee could reasonably argue that it would have been a good way to avoid redundancy, at least imminently, by placing them on furlough. That position, I think, will change from the 1st of August when the employers will have to start contributing. But for now, I think you'd need a really good reason why you're not just continuing to furlough them. In terms of there might be good reasons. So, for example, if your business is being crippled by ongoing payments such as pension payments, you could say, well, regardless of furloughing employees, that wouldn't have helped us. Whatever your decision is, make sure you've got a rationale documented. And I always suggest that someone keeps a rationale document at the beginning of the process, just to explain what's already been considered and what needs to be done now. For those that have been employed for less than 103 weeks, it's usually pretty straightforward to dismiss them on the grounds of redundancy because they can't bring a claim of unfair dismissal. But you do just need to apply your mind to whether there are any risk factors before that. So any protected characteristics, because an employee doesn't have to have been employed for any length of time, any particular length of time before bringing a claim of discrimination. So those protected characteristics are age, gender, disability, religion and belief, race, pregnancy, maternity, gender reassignment, sexual orientation, marriage or civil partnership. So if you've got a team of 5 and you need to reduce it to 4, and you select, for example, the oldest person there by a significant margin, they might argue that the reason that you've dismissed them is age. That's not to say that you can't dismiss the oldest person, but I would put in place some sort of rationale or selection criteria to just to explain why you've selected them. It's also worth bearing in mind if they've ever raised any formal or informal complaint, because if they argue that they've been dismissed because they've blown the whistle, or because they've raised a health and safety complaint, that could also be a claim regardless of how long they've been employed for. So moving on to the next slide, I just wanted to talk about collective consultation. So it's really important to bear in mind collective consultation obligations, even if there are no risks of claims for unfair dismissal. This will only apply to larger employers because it applies when you're proposing to dismiss 20 or more employees at one establishment within a period of 90 days or less. There's a really wide meaning of dismiss, by the way, here. So that doesn't just mean dismiss by reason of redundancy as you and I know it. It also means, for example, if that route that I was talking about earlier with changing terms and conditions, if you dismiss employees because they haven't agreed to changes to their terms and conditions, that would count as a dismissal for these purposes. Bear in mind also that different geographical areas might not be different establishments, so establishment has its own meaning as well. You'll need to, about those 90 days, it's a rolling 90-day period, so look back 90 days, look forward 90 days, and just bear in mind that your obligations on that kick in really early. If they apply, you need those minimum periods of consultation are set out there. You'd need to consult with your recognised trade union or standing body of elected employees if they exist, and if not, you'll need to go through an election process to get employees elected to consult with. You'd also have to notify the Department for Business, Energy and Industrial Strategy. The reason that I'm going through this and the reason that it's really important is set out in the bottom point there, that if you get it wrong, the potential award is up to 90 days gross pay per affected employee. So it's potentially huge. So I would recommend that you bear that in mind. I've just on the next slide set out some problem areas with collective consultation. Essentially, if you're undertaking collective consultation with employees on furlough, or where at least some of them are on furlough, you need to factor in that it might take more time because you're going to have issues with communicating with them. But the one point that has been confirmed by the government that's helpful is that employee representatives that can be consulted with without them carrying out work as it's defined in terms of furlough. So you can consult with people and make them redundant if they're on furlough. Moving on to the next slide, I wanted to talk about notice and redundancy pay. Now, just bear in mind, so if you're making somebody redundant, obviously employees are entitled to notice. Sometimes, well, there are legal minimum notice periods that apply. So if those legal minimum periods are more than is set out in the contract, then that legal period will apply rather than the contract amount. One of the questions that has been asked quite a lot is about how you calculate notice pay for somebody that's been furloughed. And there is an answer to this now, but it's not necessarily straightforward. So you can serve notice during furlough, but whether somebody is entitled to what somebody is entitled to be paid during that notice depends on the amount of notice that they've got in their contract of employment. So if they have at least 1 week more entitlement in their contract to notice than is the statutory minimum, then they should be receiving their contractual rate of pay. If you have agreed a lesser rate for the furlough during the furlough period, then they may only be entitled to that lesser payment. So that would apply, for example, if you've got somebody that's been employed for 2 years, 2 complete years, so legally they're only entitled to 2 weeks notice, but in your contract you've said that they're entitled to 1 month's notice, that would apply. If they're only entitled to their statutory minimum notice or less than 1 week on top of that, then different rules apply. So for the same employee, if in the notice in their contract you've said that they're only entitled to 2 weeks, then different rules apply. And the rules that apply then depend on whether they've got normal working hours or whether their working hours vary. So there's not enough time to go through how that's calculated, but you just need to bear in mind that you're going to have to look further into that. So it's not a straightforward question in terms of what the notice pay will be, but you can use, or we think at the moment, there's nothing to say that you can't use the furlough grant towards those notice payments. You'll get 80% of it back, but you may need to top it up. On the next slide, I've just mentioned redundancy pay. Now you can't use furlough pay or the money that you get back from HMRC for the redundancy payments, which are worked out based on a calculation which involves looking at the employee's age, length of service and weekly pay. In terms of how to calculate that redundancy pay, that is unclear as well. At the moment, I think the safest course of action is to base it on an employee's usual pay rather than their furlough pay. I also wanted to touch on holiday because that's something that's where there have been a few updates. So moving on to the next slide, the government has now said that if employees can't take all of their holiday this year, they'll be able to carry over up to 4 weeks into the next 2 holiday years. So that's if it's not reasonably practicable for them to take it this year because of coronavirus. The government has published some guidance on holiday. Actually, there were lots of unanswered questions and they published some guidance a day before yesterday. So they have, in that guidance, published some examples of where they think that it's not reasonably practicable for employees to take holiday this year. It's there as an option. You don't have to agree to it as an employer. You can say that they have to take the holiday this year, but you do need to look at whether they can reasonably do that. Moving on to the next slide, that guidance that I was talking about that was published the day before yesterday also provided some welcome clarification in terms of taking holiday on furlough. So holiday does continue to accrue as normal while someone's on furlough. Furloughed staff can take holiday without it stopping their furlough period, which is something that we previously didn't think was possible. We thought that it would break the furlough period, but the government's now confirmed that it doesn't. So employees can ask to take holiday while they're on furlough. In terms of whether employers can tell staff to take holiday, generally, and again taking a step back and ignoring the current pandemic and furlough, employers do have the right to state that employees must take holidays on specific days or not take holidays on specific days, as long as they comply with the notice requirements. Unless you've got other notice requirements set out in the contract of employment, then you need to give an employee twice as much notice as the holiday you'd need them to take. So if you want them to take a week's holiday, you need to give them 2 weeks notice. But there's a really important caveat in terms of furloughed employees. The guidance, and again it is only guidance, but the guidance from the government says, yeah, during furlough you can have employees take holiday, but you do really need to think about whether the employee can rest, relax and enjoy leisure time given the restrictions that they're under, which will vary depending on when whether they're shielding or not, of course, but it will be restricted for everyone. So for that reason, what I wouldn't suggest doing is getting employees to take all of their holiday in bulk. I think that it would be reasonable for you to say that employees need to take the holiday that's accrued for during the year, because when they come back to work, you can't have everybody off at the same time, for example, but you do need to think carefully about that. Holiday does need to be paid at normal rates, but you can use the furlough pay and then top up. But I've seen a lot of employers want employees to take all of their holiday so that they can get it paid 80% by the government, and I don't think that's a good enough reason to state that you want employees to take holiday. Moving on to the next slide, just very briefly, so we've got enough time for a couple of questions. So SSP, as you'll probably be aware, the rules have changed in response to coronavirus. Now, SSP is payable from day one, but only if someone's got symptoms of coronavirus or they're self-isolating because somebody in their household has symptoms. And up to 2 weeks of that, if you're a smaller employer, can be claimed back from HMRC. Government's also said that those shielding can get SSP for 12 weeks. As I say, that's caused a bit of confusion about whether they can then be furloughed. And then finally, on the next slide, I've just set out there a few predictions that I've made for the future and what we can expect to see going forward. I think we'll see lots of a real increase in flexible working requests for those people that have managed to work from home. Just to let you know about flexible working requests, employees can have the right to request to work flexibly. Employers don't have to grant it, but do need to consider it carefully, and there might be discrimination consequences of turning it down. Now that people have shown that they can work in various flexible ways, I'd expect to see that requested a bit more. I do think that we'll see an increase in grievances and employment tribunal claims, and in fact we've already seen an increase in tribunal claims, as you'd expect any time that there are lots of redundancies. I think that we'll see claims for collective consultation because, as I've said, the potential financial award is so high. So I think we'll see a lot of unions and employees looking back at how many redundancies were made and how many were proposed and at what time. Unfair dismissal claims, of course, discrimination claims, and what will be interesting about that is you look at what the less favourable treatment is, and I think depending on the circumstances and the payments made for it by each individual business, it will be less favourable treatment either to have furloughed someone or not to have furloughed someone. And as I touched on before, health and safety cases, I think we'll see employees refusing to work and cases come out of that. And the word unprecedented is being bandied about a lot at the moment, but in its true legal sense, a lot of these, well, any cases that come out of the pandemic will be unprecedented, which means that at some point we'll see case law develop to show how employers have been acting reasonably and unreasonably. I think we'll see some employers making changes to benefits to cut costs, especially, for example, if they're paying 100% sick pay at the moment. And I'd expect to see more reliance on layoff clauses in contracts, which allow employees to lay people off without pay. If we just move to the next slide, I think this is just the questions. So I am going to pass over to Laura now. Have we had some questions in?
So we've had one question from the participants, but separately I do have another question for you that I get asked quite often. So the one that we've had in is about the 8 documents that have been recently published by the government. Do you happen to know if those documents specific to colleges and universities?
I do not think that there is a specific one for universities, but what I'll do is I'll do a bit of digging into that, because we do have colleagues that work specifically with universities. So if the person that asked that can send through their details, what I'll do is I'll look into it and I'll drop you a line separately.
Perfect. The second question is for me. I get a lot of clients ask me about asking their employees to take holiday. Specifically, can they only do so if there's a clause in the contract, or is there any other process for getting employees to take holiday, and if so, what is the process?
So and in terms of furlough, or in terms of just day-to-day normal?
In terms of furlough, but there is a crossover, isn't there?
Yeah, so I would say absolutely can, as long as you're giving the appropriate notice provisions. So as long as you're giving twice as much notice as the holiday that you need employees to take, and then you just need to issue a notice in good time before that to state what days you want them to take.
That is all we've got in terms of questions. If anybody wants to send anything in last minute.
Okay, whilst we're just waiting to see whether anybody sends any more in, and by the way, well, if we could move to the next slide, I've got my contact details there, so if you don't want to ask a question now, or if you're watching the recording of this, please do feel free to drop me an email. I'm also on LinkedIn and regularly put on updates of the guidance as it comes in, so please do feel free to link in with me. Just moving on to the next slide, one thing that I think will be really useful for you all is we do have a Owen Mitchell Coronavirus Hub where all of our latest updates and webinars are, so please do sign up to that, because that's a whole wealth of information. And finally, just on the last slide, we've put an email address for our events team. Please could you drop an email through to that email address with any feedback or any questions or any webinar topics that you would like to see, and we'll liaise with HBSA in terms of providing those for you. So I just want to say thank you very much for attending. I'm really sorry about the technical issues, sorry about that, and thank you so much for sticking with us. And do just let me know if you've got any questions. Thank you very much.